This video is made possible by CuriosityStream and Nebula. There's another full-length companion video about the rights you definitely want to exercise, which you can access by signing up for the CuriosityStream Nebula bundle for less than $15 a year at the link below. So it turns out that Americans, the most free people in the entire world, asterisks, have a lot of lesser-known rights and freedoms as Americans. There is a deep well of obscure rights across these United States that are just sitting on shelves, gathering dust. So let's talk about more of the legal rights that you have, but probably don't want in any way, shape, or form. But quick legal disclaimer as always, this information is for educational and entertainment purposes only and does not constitute legal advice. Exercising some of the rights discussed in this video could result in bodily harm, drawn-out litigation, or being shunned by one's peers. Just because you can legally do something doesn't mean you should. Restrictions may apply, and please consult with your doctor and your attorney who isn't me before attempting any of these freedoms. Okay, with that out of the way, let's get started. And so we start with the Americanist of American freedoms, the right to own flamethrowers, and of course, other extremely deadly weapons. When politicians and judges decide the meaning of the Second Amendment, it's often in the context of determining what types of weapons should or should not be in the hands of a civilian population. That was the line pre-President Joe Biden took in a 2019 interview with Anderson Cooper while arguing in favor of an assault weapons ban.
Look, the Second Amendment doesn't say you can't restrict the kinds of weapons people can own. You can't buy a bazooka. You can't have a flamethrower.
Well, actually, Mr. President, it turns out that you can own a flamethrower. You also can own a bazooka, with some restrictions. In fact, there are a variety of high-powered and deadly weapons you can legally own in the United States. Under the National Firearms Act of 1934, as revised by the Gun Control Act of 1968 and the Omnibus Crime Control and Safe Streets Act of 1968, individuals can legally acquire sawed-off shotguns, any automatic weapons like machine guns made before 1986, and destructive devices like grenades, mortars, and yes, even bazookas. But I'm sorry to tell you that these weapons, commonly known as Title II weapons or NFA firearms, can only be acquired after passing a background check, paying a $200 transfer tax, registering the weapon with the ATF, and obtaining the approval of the Attorney General. Though a few states like Delaware, New York, and California prohibit ownership of all of certain types of Title II weapons, but most states allow for the legal ownership if the owner has complied with federal registration and taxation requirements. Oh, and FYI, if you decide to shoot a missile in South Carolina, you can do it as long as you get a permit first. Fun fact. Flamethrowers are an entirely different animal, though. Believe it or not, there is no federal law governing the private use of flamethrowers, also known as extended reach torches. In fact, only 2 states in the country have any restrictions on flamethrowers at all, Maryland and California. Maryland flat out bans the device, while California only allows you to obtain one if you get a permit from the state fire marshal. And as you may know, Elon Musk has even gotten into the flamethrower game by selling his own propane-powered, not a flamethrower device, named to head off issues with customs officials. However, people who have tried to take his product overseas have often found that customs officials disagree that this device is not a flamethrower, landing these people in legal trouble abroad. And like many other topics discussed in this video, you may be asking, how on earth is this possibly legal? After all, flamethrowers were historically a weapon of war, especially during World War II.
A flame-throwing tank stalks the mass funeral pyre. There is no eulogy and no mourning.
But contrary to their portrayals in movies and video games, flamethrowers are classified as tools, not weapons. And as tools, flamethrowers actually have a wide variety of legitimate uses outside of your garden variety cartoon supervillainy. Flamethrowers can be used to clear vegetation, quickly melt snow from your driveway, can be used to quickly sanitize stadium seats in what's known as flame polishing. They're great for cooking steaks, and don't tell anyone, but they work really well in training dogs and cats, though it only works once. Now, despite all of these completely legitimate uses, state and federal lawmakers from New York have tried to ban the device. In response to Musk's not a flamethrower stunt, New York state lawmakers introduced a bill to outlaw flamethrowers, though the bill remains stalled. And in 2015, 2018, and 2020, New York Congressman Eliot Engel sought to outlaw the possession or transfer of flamethrowers via the Flamethrowers Really Act. Yes, that is actually the name of the bill that he introduced. The bill never made it out of committee, and Congressman Engel left Congress in 2021 after losing a primary challenge for reasons completely unrelated to flamethrowers. But that takes us to your right to secretly record your conversations with third parties that may or may not be related to conversations about flamethrowers. A common trope in film and TV involves characters secretly recording their own conversations to catch a third party admitting to criminal activity.
It's my word against yours. $5 a day, Fluff. 365 days a year since I was 12.
Actually, it's your word against yours.
So therein lies the question, can you actually do that? Well, to give everyone's favorite answer, it totally depends. Mostly it depends on whether you're violating any federal or state wiretapping laws. Federal law permits the recording of any phone call, electronic communication, or in-person conversation, including video that captures audio, with the consent of one of the parties to the conversation, also known as a one-party consent law. So under a one-party consent law, you may record any conversation so long as you are a party to that conversation. You are that one party that can consent. If you are not a party to the communication, then at least one person must give you consent to the recording, or you may have committed the crime of eavesdropping. Now, 38 states plus the District of Columbia have adopted a one-party consent law. The remaining states, though, have a two-party consent law. Now, two-party consent is a bit of a misnomer because you first have to get consent to every party to that conversation. So if there are three parties to that conversation, you have to get consent from all three. And as a threshold matter, state and federal wiretapping laws only protect conversations when the speaker has a reasonable expectation of privacy for the conversation. So for example, even though these things take place in public, people do have a reasonable expectation of privacy in a public bathroom stall or locker room, and both audio and video recordings in such a place would likely violate state and federal law without the subject's consent. In contrast, though, a person bragging at a private party about cheating with a friend in a business deal probably couldn't claim a wiretap violation, even if this conversation was recorded without consent. In addition, federal law, along with 17 one-party consent states, prohibits the recording of conversations when done with criminal or tortious intent. As an example, secretly recording a conversation to use as blackmail would probably not be protected. In contrast, though, a federal appeals court held that a son who used his phone to secretly record a conversation about his dying mother's will could not be federally prosecuted for wiretapping because the son lacked tortious or criminal intent independent of the recording. Oh, and here's one more thing to consider. If your secretly recorded phone call takes place between two different states, you'd better ensure that both states are one-party consent jurisdictions, or you could find yourself in legal trouble. That's what happened to Linda Tripp. Back in the 1990s, government employee Linda Tripp secretly recorded her confidential phone calls with former White House intern Monica Lewinsky, wherein Miss Lewinsky provided salacious details about her intimate relationship with then-President Bill Clinton. Now, these tapes became a public sensation upon their release, and the fallout from the scandal resulted in President Clinton's impeachment, where, of course, he was acquitted by the Senate. Now, here's where Linda Tripp found herself the target for prosecution. Though DC is a one-party recording jurisdiction, Linda Tripp recorded her calls from Maryland, which requires all parties to consent. In January 1998, Ms. Tripp turned over the tapes to independent counsel Kenneth Starr in exchange for immunity. However, Maryland prosecutors indicted Ms. Tripp on state wiretapping charges anyway, arguing that federal immunity did not extend to state violations. But before that trial, the judge ruled that Ms. Lewinsky, whose testimony the state needed to prove Tripp broke the law, would be barred from testifying. And without their star witness, the state dropped all charges in May of 2000. So, your mileage may vary. And that takes us to one of my favorite American rights of all time. That is the right to steal someone's house. Yes, that is actually a thing. One of the most important rights that come with being a homeowner is the right to keep unwanted intruders off your property. In fact, a person that knowingly enters your property without permission has committed a trespass and is subject to immediate arrest. But here's an interesting wrinkle. If you commit trespass for a day, you go to jail. But if you openly trespass for years, well, congratulations, you now own that land and any buildings that are on top of it. That's right, you can actually crime your way into becoming a property owner in certain circumstances. But fair warning, this is not an advisable or easy way to earn title to property, as it usually takes decades of trespass and fulfilling other state-specific requirements for that property to actually change ownership. All right, so for purely informational purposes, here is how a would-be house thief could actually do this. Under a doctrine that's called adverse possession, a trespasser who continuously possesses or occupies real property for a certain length of time can actually acquire legal ownership to the property that they're illegally occupying. To invoke adverse possession sufficient to get ownership, the trespasser's occupation on the land must meet certain requirements. It must be hostile, it must be done without permission of the owner, it must be actual, so they have to be physically present, has to be open and notorious, the act of trespassing can't be secret and must be obvious to onlookers, and the trespasser must be in possession of the property for an uninterrupted period of time as prescribed by whatever statute we're in. The time period for vesting varies by state, ranging from 5 to 30 years, but most commonly 10 to 20 years is required of actual trespassing. Some states require payment of property taxes during the occupation period, others mandate physical improvements to the land, and some states even require the trespasser to produce some kind of document or deed relating to the ownership of the property, even if the document itself is inaccurate or carries no legal weight. Now, you might be asking, why in the world would every state give people the right to legally steal land, albeit very, very slowly? Well, the concept of adverse possession actually dates back to 6th century Roman law. Adverse possession was designed to encourage landowners to make beneficial and efficient use of their land, thereby allowing title to pass to the individual taking care of the land from the holder that has effectively abandoned it. Today, the primary justification for adverse possession is to incentivize landowners to settle title disputes by putting statutes of limitations on possible litigation and possession. In other words, if we don't really know who owns the land, it's a good idea to give clean title to someone who has had the land for a very long time and often made improvements to it. It removes a cloud of title. So to summarize, I am not telling you all to commit years of criminal trespass to maybe acquire real property, but if you've already been committing criminal trespass for decades, at the very least, now you can find out if you accidentally have acquired that real property. So good for you. Now, what if I told you you could watch another LegalEagle video, but this time it's on the rights you definitely want to exercise all the time? Well, this full-length companion video exists and is exclusively on Nebula. Because sadly, if I put it on YouTube, it would probably get demonetized and there's no way that you'd ever be able to see it. But Nebula is different. As you've probably heard by now, Nebula is home to tons of exclusive and ad-free content, like my first full-length documentary, Bad Law Words Good, my long extended interview with Mark Rober, and tons more. All of this exclusive content is only on Nebula, which you can get for free with CuriosityStream. Of course, the reason all of these videos are exclusively on Nebula is because they probably wouldn't work on YouTube because of the way that the site works. On the other hand, Nebula is a different platform without an algorithm and without any ads. Because Nebula is a place where we can experiment with content and put things on there that we couldn't put on YouTube. It's just a platform with great and unique content that's made by independent educational creators. Ones you probably already know, like Tom Scott, Thomas Frank, and Thomas Flight. As well as lots of other people not named Tom, like Lindsay Ellis, Real Engineering, Wendover Productions, and many others. There's new exclusive content released almost every day. In fact, Nebula is creator-owned and creator-operated. And by the way, we've been developing Nebula like crazy. Nebula now has apps for iOS, Android, Apple TV, Roku, Fire TV, and Android TV. And my fellow creators and I really care about Nebula. So we're thrilled to be partnering with CuriosityStream because they're the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crime. So if you like my videos, you'll love the stuff on CuriosityStream. Now, the best way to get access to Nebula and all of this incredible content is definitely through the amazing CuriosityStream Nebula bundle deal. And with its current sales price, it's less than $15 a year to get full access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you're a CuriosityStream member. I genuinely don't know a better deal anywhere, where you'll get 2 streaming sites, both with content you'll actually watch and enjoy, all for less than $15 a year at the current sales price. But what's more, signing up will actually help countless independent educational creators beyond just LegalEagle. So be sure to get this bundle deal by clicking on the button that's right here on screen right now, which will take you directly to curiositystream.com/LegalEagle, where you can sign up. Or you can click on the link that's down below in the description. It's a great way to support educational content and get tons of exclusive content, which you should go watch right now. Or you can click on this playlist over here with all of my other educational-ish videos. So click here or I'll see you in court.